I hope so. Yeah, I could see that having an impact.
What? In Missouri?
Oh,
Yeah. When did this happen?
oh. Well, yeah, I imagine he's. All right, you're on the panel. Yep. That's all right, everybody. I guess we'll get started. Yeah, 10 after 3.
I barely have all the honors.
Yeah, this is about the turnout I expected for something as exciting and riveting as labor law. I'm Bill McMorris. I'm a reporter with the Washington Free Beacon. I cover labor issues, and we have gathered for you a panel of the 4 brightest minds in all of labor politics. We have Tammy McCutchen, who is a former Department of Labor administrator, as well as an employment attorney at Littler LLP. I believe I got that right.
Yeah, always.
No? Okay. We have Mark Mix, who is the president of National Right to Work Committee. We have State Representative from Minnesota, Nick Zerwas. And we have, as a last-minute replacement, as we lose the people from Missouri, we have Vinny Vernuccio, who is a labor policy expert at the Mackinac Center for Public Policy out in Michigan. So he's, at the forefront, ground zero of the labor movement here. So we're going to hear from Ms. McCutchen on just general opening statement about the current state of labor relations under the Obama administration. Just to save you some time, it's not very good right now. Tammy.
Thank you. And what I want to focus on is the executive overreach that we've seen out of the Obama administration as it tries to give organized labor their wish list. I'm going to start at the NLRB very quickly, but also want you to remember that because that is where the unions are having their most influence in changing policy and changing regulations, but also, even though we're an NLRB panel, I wanted to note that the AFL-CIO and other unions also are having a great impact on policy, regulations, and litigation, both at the Department of Labor and the Equal Employment Opportunity Commission. So what are some of the things that Obama has been doing with his pen? Not necessarily him, although he has authored, a bunch of executive orders that employers have to deal with, but through his executive agencies. At the NLRB, last year tried to require employers to all post in every workplace a poster that says, "Hey, you have a right to join a union." Well, there was the National Association of Manufacturers challenged that because there's really nothing in the National Labor Relations Act that allows you to require an employer who hasn't violated the act to put up a posting. And the D.C. Circuit invalidated those regulations, stating that, you cannot penalize or find a violation because an employer tells their employees that they have a right not to join a union. So it's really a free speech issue. You can't force an employer to post a notice about the benefits of unionization with which they disagree. More recently, of course, we have coming up, effective on April 14th, there are new regulations called the quickie elections, and this is a pure payback to the unions. Currently, it takes the median from the time a union files a petition for an election to the time they get the election is 38 days. Apparently, that's not quick enough, even though 94% of elections are held within 56 days, and unions are winning 65% of those elections. Nonetheless, the unions have said for a long time that the election procedure takes too long and is therefore unfair. So what happens effective April 14th? Effective April 14th, employers are going to get the notice of the election petition via email, and I hope those busy executives actually read their emails promptly, because they have to post the notice 2 days later. There's going to be a hearing on the election 8 days after that, and then the election as quickly as the NLRB says. So basically, you're in a position now under these new regs that go into effect in April that you could go from getting a petition for an election in your email to having the election in 2 weeks, which of course, what does that do? Remember, unions start their campaigning months and months and months before they actually file in the NLRB for a petition. Right? So they could have been talking to your employees and convincing employees that unionization is the right way to go with no opposing voice, for 6 months or even a year until they feel they've got enough employees on their side to win. They won't file a petition if they don't think they have enough employees who are going to vote for them. On the other hand, the employers are going to have 2 weeks to convince that they're employees. And of course, there's been litigation filed both in district courts in Texas and here in DC, alleging that this is a violation of the employer's First Amendment rights and also a denial of due process, in addition to not being supported by the actual act. Another thing that's really pernicious that's going on, that's really driven by the SEIU, is the attack on franchising. Has anybody heard about this? Basically, the NLRB since 47 years, have never found a franchisor to be a joint employer with his franchisees. What does joint employment gives you? It means, and this is what's happening at the NLRB, is NLRB wants to hold McDonald's, the corporate franchisor, responsible for every labor law violation by every franchisee in America. Can you imagine? It will basically eliminate the concept of franchising, because if you're going to be responsible for compliance for every employee working at any McDonald's store, what are you going to do? You're just not going to have franchises. You're just going to have company-owned stores. So this is an area where the Obama administration is really trying to put small businesses out of businesses, because most of these franchisees are single store, two store, they're small businesses. What's happening is that the NLRB General Counsel, a guy named Richard Griffin, is trying to change the definition of who is a joint employer. It used to be that you have to have direct and immediate control over hiring, firing, discipline, supervision of the franchisee's employees. Now here's what he wants it to be: direct or indirect control over working conditions, or having the unexercised potential to control working conditions, or where industrial realities otherwise make it essential for meaningful bargaining, which means whatever the NLRB wants to declare somebody a joint employer, they will be. Since December 2004, Griffin has filed 19 complaints against McDonald's franchisees and naming McDonald's corporate as a joint employer, and so more to come. Now, getting back to how the DOL is also being influenced. DOL is also going after franchising. My old job, administrator of the Wage and Hour Division, is now held by an academic. In fact, in the Department of Labor, you probably won't be surprised to know there's not a single person who's ever had a job in the private sector. They all come from unions, employee advocacy groups, state law, or academia. So the DOL is regulating without actually knowing what it takes to run a business. There's this thing, the administrator, David Weil, he hates what it calls fissured industries. And that is any industry which includes businesses who receive services from workers who are not their direct employees. And of course, franchising is a big issue, but also subcontracting and independent contracting. And his theory is that the top employer is using franchising, subcontracting, and independent contracting in order to shed responsibility for complying with employment laws. And under his initiative, what he's trying to do, and you guys can judge whether you think there's collusion between the DOL and the NLRB on this. I was at a chamber meeting, their law employment meeting, and we heard from the general counsel of the NLRB about his plans for franchising. And then David Weil spoke after. And I asked him, because what they're trying to do is they're trying to get his plan is he's going to do a strike force for a particular brand. Let's just take McDonald's, because I've already mentioned them. They're going to send out wage and hour overtime law investigators to like 20 franchisees. and then publish all their violations using social media, press releases, and then try to pressure the franchisor into signing what they call an enhanced compliance agreement. And in that enhanced compliance agreement, they want the franchisor to include, rewrite their franchisees agreement to require compliance and allow monitoring and training and oversight of their franchisees' practices. Of course, and here's the kicker, if you enter those agreements as a franchisor and you take control of all this employment practices stuff, guess what? NLRB is going to find you're now a joint employer. Right? So if you're trying to get out, you're trying to do what DLL wants, the next thing you know, you're a joint employer under the labor laws. And I think it's pernicious for them to double team the franchisee community that year. The one other thing, and I'm going to end with this, even though I have lots more, because I litigated this. We recently won, my firm and I recently won a case against the Department of Labor where their home care regulations were completely invalidated. These home care regulations basically would have devastated the home care industry. This is the industry that takes care of your aging parents when they're too old and infirm in your home, in their home, rather than having to institutionalize them. And the history of it is the Clinton administration tried to propose regulations to vastly narrow the exemption from overtime for these home care workers. One of my first official acts at DOL was to withdraw those regulations. Then there was a Supreme Court case where DOL's more expansive definition at the time was challenged. The Supreme Court said, nope, that definition is just fine. It is supported by the statute. Then there were no less than 6 bills introduced in Congress when the Democrats had control to narrow the exemption, and it didn't even get out of committee. And finally, though, in 2003, the SEIU, who really wanted this, got their wish granted. The Obama administration issued final regulations which basically would have taken away this overtime exemption for 98% of home care workers by stating that only home care workers directly employed by the family could be exempt, so any home care worker working through a company, companies that do like background checks and have insurance, that if you're employed by a company, you can't be exempt. We got a great decision from Judge Leon in the D.C. District Court, and it's a joy to read. He says things like, DOL's regulations bespeaks an arrogance to not only disregard Congress's intent, but to seize unprecedented authority to impose overtime and minimum wage obligations in defiance of the plain language. Even better, redefining a 40-year-old exemption out of existence may be satisfyingly efficient to the Department of Labor, but it strikes at the heart of the balance of power our founding fathers intended to rest in the hands of those who must face the electorate on a regular basis. This is a guy who needs to be on the Supreme Court. What do you think? Of course, it's now DOL has appealed the decision, and guess where we're going? We're going to the D.C. Circuit. In case none of you know about the D.C. Circuit, they have 4 new Obama appointee judges. So unfortunately, my hope for succeeding before that court is not high. But this decision is worth reading.
Tammy will also be running a tutoring service to help people pass the bar exam after this panel. So, Mr. Mix?
Yeah. The topic is there's no I in Teamsters. Well, there's very little I in American labor law. Unfortunately, for the last 80 years or so, federal labor policy has not been in favor of the I, it's been in favor of the we, and the we is organized labor. Let me just give you some context here as we talk about the National Labor Relations Board. This is a direct quote from a judge in a Pennsylvania legal situation regarding the University of Pittsburgh's Medical Center. We're helping employees up there avoid a corporate campaign by the Service Employees International Union. Here's what the judge said recently about the National Labor Relations Board. Quote, the scope and nature of the requests, coupled with the National Labor Relations Board effort to obtain such documents for and on behalf of the Service Employees International Union, arguably moves the NLRB from its investigatory function and enforcer of federal labor laws to serving as the litigation arm and the union and the co-participant in the ongoing organization efforts of their union. This is a judge talking about a federal agency saying they've now become an arm and an organizing tool for the Service Employees International Union. This is where we stand now with President Obama and his National Labor Relations Board. Many of you may have followed the fact that the Supreme Court, on a 9-0 decision, decided that the president usurped constitutional authority, violated the Constitution by appointing people to the National Labor Relations Board. I know this is not a high-intensity issue. It's not a marquee issue for lots of you. But labor policy is one area where our side is actually winning. And there's lots of exciting stuff happening across the country. And this National Labor Relations Board that is the enforcer of our federal labor policy, we're going to have to bear it out for another 2 years because they are really in control of the agenda as it relates to organized labor. At the National Right to Work Legal Defense Foundation, we currently have 83 charges pending in front of the National Labor Relations Board on behalf of employees who are trying to vindicate their rights. And we don't hold out a lot of hope for these employees with this current board, this 5-member board that is nominated and confirmed, nominated by the President, confirmed by the Senate, in many cases on deals, but that's another story. But it is going to be a very difficult slog. The solution, though, is to win at the state level and to protect employees by passing right-to-work laws, which has been something that's been we've been done very well over the last couple of years. In fact, it appears that today you may hear an announcement from a governor from a Great Lakes state that there may be the 25th right-to-work state here before too long. Number 23 and 24 are Indiana and Michigan, and that was an important part. But I encourage you to pay attention to what the National Labor Relations Board is doing. All of the issues that you and I fight for here at the Conservative Political Action Committee are often funded, the other side of the argument is funded by organized labor because of their compulsory dues power to force workers to pay dues or fees to get or keep a job. It's an outrage in a country founded on individual freedom that we have to fight this, but we do. And the fight is raging now as the executive branch tries really hard over the next year and a half to give organized labor substantial new powers to force workers into unions.
Thank you. Vinny?
Great, thanks, Mark. Well, my apologies, I am not Representative Diehl, but Mr. McMorris was so kind to ask me to fill in. There was a tragedy, if you haven't heard, in Missouri today. Anyway, thank you for the opportunity to be here and to speak, and just want to echo some things that Mark said. It's a great time in labor law right now. Things are going really well on almost all branches. From the states, you have Michigan, you have Indiana, soon you have Wisconsin, you have Missouri that just passed right to work out of one house. You have states like New Mexico that may have some hurdles but are seriously looking at right to work right now. You have government union reforms happening across not just the Great Lakes states but the country. In the courts are finally siding with workers and with freedom. You have court case after court case. SEIU versus Knox, where the SEIU tried to take people that disagreed with their politics and use their money to fight for a constitutional amendment to force them to give more money to politics. Well, they took the money and then gave it back, and that was supposed to be okay, and since we're having so much fun quoting Supreme Court justices and other justices, my favorite was Justice Scalia's quote during that case of, it amounted to an interest-free loan to the SEIU, and guess what? That's illegal. To Harris v. Quinn, which Tammy was talking about before, and to go one step further to make it personal, we had a case like that in Michigan where there was a couple called Robert and Patricia Haynes, and they lived in Macomb Township, Michigan. They were taking care of their adult disabled children. They didn't send them to an institution. They didn't pawn them off on the government. They didn't ask somebody else to watch their children that couldn't take care of themselves. They kept them home. And as good parents, through their adulthood, took care of the children that couldn't take care of themselves. For that, they got help from the state. They got in the form of Medicaid money. Well, the SEIU cut a deal with the then Democrat governor, Jennifer Granholm, and got to organize this couple, take mandatory dues from them. So apparently, Robert and Patricia Haynes needed a union to take care of their own children. Well, thankfully, because of Harris v. Quinn, that scheme was marked illegal. Unfortunately, it was made illegal after the SEIU skimmed over $35 million from people like Robert and Patricia Haynes. And soon we'll have a case you may not have heard of, but that will hopefully be heard before the Supreme Court. They haven't granted cert yet, called Friedrichs versus California Teachers Association. The Friedrichs case is saying that, guess what? These government unions, they're political. Shocking, right? That these unions that are fighting for taxpayer dollars for themselves and greater taxpayer expenditures are actually political actors. Well, if the Friedrichs case is granted cert by the Supreme Court or able to be heard by the Supreme Court and the Supreme Court decides favorably, then the decision will hopefully come down that these government unions are inherently political actors, and because they're inherently political actors, any contribution at all is considered a political donation and therefore will be compelled speech. Folks, if they grant cert on this case and decide favorably, it'll be a sea change. Instantly, you could see right to work for government unions across the country. And what is right to work? All right to work says is that a union can't get a worker fired for not paying them. That's it. It doesn't do anything more. All the rhetoric you're hearing, it's false. It doesn't affect collective bargaining in any other way except for, say, telling a union, no, you can't say this worker is not paying me, they have to be let go. Still bargain over wages, hours, working conditions, anything they could before, they can bargain for after. And just to echo what Tammy was talking about with the NLRB, because that's really the last vestige of where the unions are right now. They're losing at the state level, they're losing in court, they're not going to get much through Congress, so they're doing things through unelected bureaucrats, like the National Labor Relations Board and like the Department of Labor. And just to give you a quick juxtaposition, the NLRB has kind of a Goldilocks problem right now. They're either too big or too small, and they're doing whatever they can to fit a union in to make it just right. So you were hearing about the quickie elections, which are speeding up these elections. You heard about the joint employer. So that's the too big. They're trying to make it so they can try to unionize an entire franchise. So instead of going to the McDonald's on the corner, they're going to go to McDonald's headquarters to try to organize them, and you heard the justification for that. But then on the other side of that, where they're trying the too big problem, they're going too small. Recently, the National Labor Relations Board just affirmed a union for a cosmetics counter in a Macy's. Let me tell you how this worked. They couldn't organize all the employees at the Macy's, which is typical because it's like workplace, that's how you organize a unit. So they said, well, we can't organize all of them, but you know what? We can just get the handful in this one department. So instead of going too big, now they're going too small, and they're trying to organize micro unions, hyper-specific bargaining units, because they can't get the overall unit, and they just want to get their foot in the door. So that's the Goldilocks problem, and I tell you, the joint employer is extremely scary.
Well, and I think the quickie elections sort of combine with the micro bargaining units to be really pernicious because it's harder to win big units because you can't get your 50+% of the votes. So with the quickie elections and these micro bargaining units, it makes it almost impossible to keep a union out of your workplace.
That's right. And just in closing real quick, I want to go back to what Mark started with, that there's no I in federal labor law. And frankly, that's why the unions are losing. Because they're still in this industrial revolution, last century business model that is one-size-fits-all contracts that is more about the we and rather than the I. We just published a study called Unionization for the 21st Century that is showing positive recommendations, free market recommendations to actually grow union membership and improve unions. So take that, everyone that says we're anti-union. We want to see stronger unions, but we want to see unions that are focused on the individual, that are focused on the free market, that are without compulsion. If workers, especially workers in the private sector, want to form together and join a union, they should be free to do so. But no one should compel a worker to pay for representation they don't want, and no one should compel those workers to accept that representation. and hopefully this will be the new forefront in labor law. So, Bill, thanks for inviting me up.
Of course. Representative?
Yeah, so I guess we've missed the party in Minnesota. the blue oasis that it's fun being a Republican in Minnesota because you go to one social event and you meet all the Republicans. It's pretty easy. No, it's interesting, and we see a lot of parallels in Minnesota to what is going on in at the federal level, where we had a governor that through a significant executive overreach decided to give a big, giant, wet kiss to the unions that got him elected by using executive order to, by a stroke of a pen, trying to unionize in-home child care workers and personal care attendants. Now, a judge later said, no, you can't actually do that. You need to pass a law to do that. And so, SEIU, they're not dumb. AFSCME, they're not dumb. And so they dumped a ton of money into state legislative races the following year. And Minnesota had Republican control of the Senate and of the House. And in one election cycle, when Republicans were outspent by Union Democrats 4-1, they took control of the House and the Senate. They had their DFL governor and Mark Dayton already in place, and we saw their number one agenda item come through: the forced unionization of in-home child daycares and personal care attendants. And everyone went, well, this is just crazy. And so it was interesting as that bill went through the legislative session and through the process, they had even Democrats that said, well, why in the heck would my neighbor who takes care of 4 other neighborhood kids need to be in a union? And if you're saying that this is a benefit or this is helpful, why would we focus on the poorest families that are getting a child care assistance credit for quality daycare? How can we say that we're going to take money directly out of that state credit and give to the union as part of the dues and say that that's helping kids and that's going to improve daycare? And so that bill was not going to get out of committee and get to the full floor of the House. And so they did something genius. They combined the PCA bill, the in-home care bill, with the child care piece of legislation into one bill and never talked about daycares again. And only focused on these sick individuals that require this very technical support at home in this care, and these people that are doing the work that, God bless them, and they need to be represented by a union. And they were able to force that through the House 68-66. The Speaker of the House, Paul Thiessen at the time, left the voting board open for about 45 minutes, and we saw the majority leader go over to a moderate Democrat and scream at her until she started crying, and then push the green button in order for that to pass. Now, that type of overreach had ramifications in their election as they lost control of the House. But the big thank you came back to Governor Dayton. As for his reelection, he was able to outspend the Republican candidate through third-party union spending nearly 3-1, and was reelected with a slim majority of the vote. The Harris v. Quinn turnabout has changed what we're looking at as far as compelled union participation and dues. But what we're seeing in Minnesota, the impetus behind is what we've seen in other states, and that is, hey, if we can't force dues from people, then, hey, you're running an in-home daycare. We think if you're going to take state dollars to provide daycare services, you ought to meet a standard training level. And you know what? Sorry, guys, only SEIU or AFSCME can offer that level of training. And so we can't compel you for dues, but for your daycare licensure or your PCA licensure, we're now going to pass laws that say you need this many continuing ed credits, and we're the only game in this. We're the only game in the block. So come get your training from us. And so they're just finding it. It proves what this has been about all the time. It's not about the quality of the daycare. It's not about the service. It's not about the poor PCA worker that needs this comprehensive union protection. It's you have state money, we want our cut. And here's another way, through forced training, where we're the only purveyor of the training, we're going to get our slice of the pie. And that's what we're starting to see in Minnesota and other states across the country.
Thank you. I liked what Vinny was pointing out before about, this is a time to actually be optimistic about the Republican and the conservative agenda, because we actually are winning the fight against labor unions. And as proof of that, you can even look at what the left has done. Media Matters was accused of bullying union organizers within its own ranks. David Brock opposed unionizing his own employees, even as they were writing blog posts about how good and how beneficial unions are for workplaces. It's pretty astounding when we've won over David Brock. I think we're winning the debate. And I think, he was eventually peer pressured by the left to just accept them. But it was great to see those press releases coming out saying David Brock calls himself a progressive but hates unions. I fist pumped. It was fun. So I guess that is why we've seen this sea change in labor relations over the past 50 years. There are now more government employees who are union members than there are private sector union members.
Like a factor of 2 or 3, yeah.
Yeah, it's been that way for a number of years now. And part of the reason is that right to work has spread throughout the states, and the private sector has been given this choice. But even as right to work passes in states like Michigan, public employees still, teachers in school districts are still forced as a matter of hiring to pay union dues. And I guess that's what's so interesting and exciting about this Friedrichs case that will hopefully go through the Supreme Court, is that this could actually end this practice. And I was wondering, what does that do in a state like Minnesota? If you see these teachers' unions lose members, that means they lose money, which they were using to buy elections and politicians.
Yeah. No, and I think you're 100% right. We're going to need that outside force for a good amount of change. The one, I don't want to be all doom and gloom on Minnesota. The one very exciting thing around, especially the teachers union, which is Education Minnesota, the very interesting thing in the sea change that we've seen is teacher choice, school choice, and having competent teachers that really want to be in the classroom are now finally hitting the forefront. In Minneapolis and St. Paul, sadly, in those two school districts, we're averaging about a 50% graduation rate. That's in a state where in any other district, you're above 95%. Your minority graduation rate is around 30%. Your Native American graduation rate is around 27%. And so when the Washington Redskins came to town, all the unions were protesting this horrible thing that, this racist football team with their name came to town. And we took out this huge ad in the Star Tribune, and we said, if you really care about Native Americans and Native American children, why aren't you protesting your school district that's graduating them at a 27% graduation rate? Don't tell me you care about kids and then go sit outside a football stadium and leave your school district alone. So for the first time in the history of Minnesota, we have a DFL introduced bill, a Democrat introduced bill in the Senate to eliminate last in, first out. And we have a bill in the House of representatives that will pass today, House File 2, to eliminate last in, first out. Now, the governor is bought, traded for, and sold by Education Minnesota. So he likely will not sign the bill, but I think we're starting to start a bipartisan discussion that these types of archaic union rules that don't care about performance, that don't care about results, are certainly in an education setting hurting kids. So I think we're seeing some of that naturally rise to the surface.
Absolutely. And if we're talking about the amount of money that's flowing into these political candidates and is influencing how they're going to make their decision, I mean, how do we see that play out in Michigan, where the public employees unions, spent a ton of money on not just the 2012 election cycle, but 2 constitutional amendments as well? Are we seeing an effective countering to the union narrative when it comes to claims on the public treasury?
Well, just to start, to go back, if anyone's not familiar with last in, first out, what that means is that because of seniority rules, a union requires that a school district or anyone with the last in, first out rule let go the teachers or the worker with the least seniority. So you could have a teacher who just started, and I'll give you a concrete example. In Wisconsin, the teacher of the year was let go because of last in, first out. In fact, you got to love this propaganda bill that they were coming out against Scott Walker, saying that because of his reforms, the teacher of the year was let go. Well, his reforms actually prevented that practice. And eventually when that came out, but it's firing very qualified, energetic, young teachers, young workers, at the expense of those with more seniority. And performance doesn't come into account. So just in case anyone was not familiar, in Michigan, the unions are still trying very hard to grasp onto and hold on to forced unionism. We had a lag time between the time Right to Work was enacted, the legislature voted on it, and the governor signed it in December. But because of a constitutional provision, it didn't go into effect until March. So the unions had about 3 to 4 months to extend those contracts, in some cases extend those contracts by up to 10 years. So 10 years of forced dues passed when Right to Work was enacted in Michigan. That's one way they're trying to bypass it. They're also making it very difficult for teachers to opt out and for some public workers to opt out. They're limiting the opt-out period to a very small window. In some cases, it's the same month, which is actually better than some of the others, which say that you have to opt out between 60 days and 30 days prior to your anniversary date. So basically, you need a calendar and a calculator to figure out when you can opt out, and you can't even ask the person you're working next to because your anniversary dates are different. And guess what? If you don't do that, they can't get you fired, but they can send you to collection agencies. And the teachers union in Michigan is actually sending their own members to collection agencies, trying to ruin their credit to extract every cent of forced dues they can. So, once Right to Work is passed, the game's not over. There's still things that the unions are doing to try to collect those forced dues, and it's something that we're looking at in Michigan and in several other states. And Mark's group, National Right to Work, has been fantastic, helping out on the ground, defending those teachers, defending those workers with us at the Mackinac Center. They have cases, we have cases, but are just making sure that everyone that does not see the value of union membership does not have to pay for it. And Mark, thank you for all the hard work that you guys are doing out there.
Glad to do it, yeah.
It's sort of like trying to get a gun license in D.C. Sounds to me like, it's great that we're winning in the states, and I think local is the place to fight the battles against the union because, we are seeing all of these executive orders, regulations, litigation, executive orders that's making it really hard to fight at the agency level, and things are being passed that are horrible. And the problem is, yes, we're winning in the courts. The home care regulation, the posting regulation. I have no doubt that the quickie election cases will prevail. But, these are just you and me litigants who have to wait for years through court cases in order to get to restrain these out-of-control agencies. So I think, even though it's hard and it's long, I think if you care about these issues, it really is important to try to fight the federal agencies at the agency level as much as you can before having to, so you can prevent these things from happening rather than having to go to long litigation. Or you can just give it all up and let's pass litigation in the states. I always had an idea, and I'm going to say this. You know what? If you have forced union dues, I think states should enact laws that say every time that there's a proposed wage increase in a public employee contract, it has to go through the electorate for approval before it gets in. What do you think the unions would think of that?
They wouldn't be happy. But to expand a little bit on Vinny's point about the Friedrich case and this line of legal questions that actually made it to the Supreme Court in the Harris case and started with the Knox case. The National Right to Work Legal Defense Foundation argued both those cases in the Supreme Court. And to Vinny's point, the Supreme Court in Harris was ready to say, we believe they were ready to say, that everything that a government union does is indeed political. They're trying to redress their government, and therefore, this is political speech. And if the question before, I believe the court there was pulled back. Alito, I think, and others were ready to go all the way and say, yeah, they're right. No one can be forced to pay anything as a condition of employment. And to mirror what Vinny said, that would be a national right to work law for every government employee, for every teacher, for every firefighter, police officer, every government employee across the country. That would be a national right to work law. The Friedrich case is there pending. The petition for cert has been filed. The answers are coming in. We could have a decision on whether or not the Supreme Court will take this case by April 27th, I think is the earliest. It's more likely they'll conference it in April, and maybe in May they'll decide. The good news is there are other cases following along. We have a case in the Fifth Circuit called CERNA, that brings real full-time employees under the Railway Labor Act to the court with the same proposition. We have a case in Massachusetts that's working its way through that has state employees that are being forced to pay fees to the union to keep their jobs. A very good situation, a Harris fact pattern, but these are actually employees of the state. They're not home health care providers who, in this case, the Supreme Court said we don't have to get to whether or not all government employees need this protection. The class in the Harris case were home health care providers. Again, our plaintiffs there were were mothers who were taking care of their own children in their own homes. I mean, just amazing that these people had to fight this battle. But they didn't have to get there because they could segment the clients here as being different than quote-unquote state employees. But really, we are very, very close, and we got to continue to push. As Vinny said, it's a time to be optimistic. I've been doing this for 28 years, and the fact that there's been hopefully 3 new right-to-work laws in the last 3 years is something that we'll smile and take to the bank. But to your question, Bill, organized labor self-reports that they spend $1.7 billion every 2 years on federal elections alone. They self-report that. This is numbers that come out from their books. And so they are a big political player, and we owe it to ourselves to learn about how they operate and to be engaged at the local level and at the state level. And anybody we can find that's a daycare provider, Jennifer Parrish in Minnesota was a client of ours. We actually struck down the Dayton executive order with Jennifer's courage up there and continue to litigate on behalf of daycare providers in the state of Minnesota. But there's work to be done here. But we as a movement need to understand that it is organized labor that's the engine of the left. That $1.7 billion is not going to candidates that believe in things like smaller government and lower taxes and more freedom for individuals. They are out there progressively pushing for larger government, more control. The Obamacare bill, clearly, in 2009, we wrote about this. Vinny did work on this as well. This is nothing but a union organizing campaign. Literally, there's a potential class of literally millions of home health care providers under the Obamacare that will be subject to unionization through executive action, through the Department of Health and Human Services and Department of Labor. So they've got a very long-term vision for where they want to go, and that is France. That is, Spain. That is a labor policy out of Germany where, you just accept it and everybody understands it. Not
China?
Here in America. Not here in America.
China.
Yeah, China. Right.
Oh, yeah, the work conditions over there are great.
It actually gets worse than that. Besides just the union organizing via Obamacare, you look at them eating their own and harming their own members. You saw Obama just vetoed the Keystone Pipeline. The AFL-CIO has been vehemently against the Keystone Pipeline, while their own member unions, like the Steelworkers Union, has been saying, no, what are you doing? This is going to get us jobs. Are you kidding me?
Yeah, TransCanada has promised that all the jobs will be
Yeah.
union jobs, every single one on that
So
pipeline.
because of the political ambitions of the top of the union movement, the AFL-CIO doing what's called the Blue-Green Alliance or joining up with the environmentalists for political purposes, they're harming their own membership, the own potential for their own members to get jobs, have good jobs, building this pipeline, but they'd rather play politics with it. And it's just disgusting that those members in non-right-to-work states are forced to support views that will cost them jobs.
You know, the Obama administration is going after the fracking industry, too, through the DOL. DOL investigators have visited every fracking site in Pennsylvania to uncover wage and hour violations, which they have done. Now, why would they go to investigate people who are making $20, $30, or more dollars per hour on a fracking site? You can speculate yourself.
Well, I'm just an unbiased reporter. I, of course, never speculate. This is actually a very interesting point. Is we're seeing the big criticism of the new left has been that they largely abandoned the white working class, the old kind of blue collar workers that were in their coalition, and it seems like the only thing that's really holding the unions in place and keeping them with a seat at the table is the fact that they spend so much money on politics. But we've started to see even unions take issue with President Obama over the Keystone Pipeline, over EPA regulations. The Coal Miners Union has complained about this. And Keystone, environmental issues, all of these things. Do you think it's going to drive a wedge between unions and their members, further alienating them from their interests?
I do, and I'll add another one to that, is immigration, which of course has been in the news as President Obama is trying to give out work permits to anybody who's actually in the country. For many years, organized labor opposed immigration, especially illegal immigration, because it drove down wages. People coming in from Mexico will mow your lawn and work on a construction site and pick your produce for very low wages, sometimes below minimum wages when they're here illegally. And now the unions are very supportive of immigration, which seems to me to be against the interests of American workers by making cheap labor available. And so I think that issue, too, will drive a sharp wedge between the average Teamster and the Teamster leadership.
What about you, Senator?
And we certainly saw in Minnesota, in northern Minnesota, which has a great history of miners around mainly iron ore, and there's a new process for copper nickel mining to go back to those used iron ore mines and basically remine it again through a new process and float up precious metals, copper and nickel that you have in cell phones and cadmium and other precious metals. And what we saw is an environmental push that there's been 3 mines in northern Minnesota going through a state permitting process for 12 years. And for 12 years, the state hasn't yet told them whether or not they can apply for the permits they need, because there still needs to be more environmental analysis. Now, the governor has been in for 6 years and has consistently appointed people that sit on these boards and commissions that are doing nothing but stall. And so when I was up north in northern Minnesota, literally you can see the Canadian border. I don't want my Sarah Palin moment, but literally you can see the Canadian border. And it was every household said, proud union member, dump Dayton. And because they knew that these people were not being allowed to work because of these environmental programs being pushed by the governor's administration. The craziest thing happened about a month before the election. All of the union employment group went up there, and they had town hall after town hall and literally browbeat people. The signs were gone, the opposition was gone, and you had neighbor turning on neighbor, and we had in some counties in northern Minnesota 85% turnout on election day, and going 70 to 75% for the governor.
Makes perfect sense.
Just unbelievable.
So we saw the exact opposite happen in Wisconsin, though, with Governor Walker during the recall winning 40% of union households. And I guess, does that show kind of the disconnect between the public sector unions and the private sector unions? The exit polls didn't really differentiate, but the fact that so many of these union households were voting for the governor, you have to think that they probably were not coming from the teachers' union. But what did you guys think about that on the
Well,
Midwest?
Vinny can speak to that better, but in Michigan, I mean, Governor Snyder, who was not really, he was more of a reluctant supporter of right to work. He came along very nicely, thanks to lots of stuff that Mackinac did to convince him that it was the right thing to do. But the bottom line is this, is all the politicians that voted for right to work, and Vinny, correct me if I'm wrong, I don't think one legislator who voted for right to work was defeated that ran for office in the next election. I don't think there was one. And certainly Snyder won, and Walker won.
Mark,
And
I'm sorry. What state are you talking about?
I'm talking about Michigan. Yeah.
Oh, Michigan. Okay.
Yeah.
Because that was true in Indiana. That was
Yeah.
true in Wisconsin. It's true in Michigan. Even true
Kasich.
in Ohio
Yeah.
with Kasich. So
Yeah.
I'm sorry. I just want to clarify.
That's okay. Yeah. I was trying to throw you a softball there, but it wasn't big enough around.
Yes, you
But the
wouldn't
point
swing,
is,
Vinny.
what we're learning, and what we're learning from the Great Lakes states more than anything else, is that it is politically profitable to stand up on principle and stand up for freedom for individual workers. You know, we've often said, I think all of us that talk about this, is that when the Irish Catholic steelworker in Gary, Indiana, understands that his brothers and sisters in the government union are increasing his property taxes, increasing the size in government, and trying to take away his guns, there will be a chasm and a fracture between the unions and the private and the public sector, and frankly, that's happening right now.
And I'd like to ask you a question. How much do the international union presidents make?
Oh, I don't know. I think Eugene Upshaw from the NFL Players Association was the highest paid union official. I think he was making $1.6 million a year. I'm not sure whether Demarius Smith makes that much. He probably makes more now, but they do right well. They do right well. It's, Randy Weingarten from the American Federation of Teachers, I think, is up over $500,000.
Including $100,000 for her limousine every year.
So
That's
they're
right.
like one percenters,
Yeah,
Yeah.
they are one percenters. There's no question about that.
trying to take
they do
money
right well.
compulsively away from employees who are in the bottom
I
often.
want to steer the
that issue is
conversation.
important. We understand it. I mean, the individual freedom that we talk about is really the number one selling point. 80% of Americans agree with us on that, and as long as we stick to that, we can defend this position. Union officials want to drive us out into this area where we talk about all this other stuff, but staying on point about individual freedom is how we win this battle and how we will win this battle. Yeah.
I just want to steer the conversation away from sports because I'm all about the guaranteed money and Major League Baseball. It's made baseball the best sport in the world. So I'm a sports socialist. Now, one thing we only alluded to, and we are running out of time. I think we have about 1 minute left. Is LM2s. I think this is actually right there at the bottom. These are federal labor filings that every union is required to submit every single year, and they have to break down how much money they collected in dues and how they actually spent that money. And what I've seen in looking at, since we're on the subject of Randy Weingarten, the American Federation of Teachers, collected about $300 million in revenue. $200 million of that was borrowed, taken on as loans. And when you look at how they actually spent the money, they spent more money on union overhead costs and political donations than they spent in membership services. And that's what we're seeing in a lot of these unions. And these reports are up there, very simple to read, and they're there so union members can see how their dues money is being used. And not enough people look at them and actually study how this money is being used. So I would encourage all of you who want to get involved in this, the easiest thing you can do is just read the first 3 pages of the LM2 and see how much the union presidents are making and
Bill,
see how that money's being spent.
Not to interrupt you, but I see a lot of pens scribbling down. The URL, actually, there's a redirect. You can just type in unionreports.gov. You don't have to do that KCR nerds or whatever that says.
Are you
up there.
serious?
Yeah,
Oh my
unionreports.gov.
gosh.
Make life easy.
Look what it did to my finger.
I will point out the agency within DOL who collects these, the Office of Labor Management Standards, which enforces rules against unions, is the only agency within the DOL whose funding has declined in this administration.
And the Teamsters were actually subject to even more onerous regulations and reporting requirements than every other union. They had a special exemption because of their ties to the mafia. And they were, that's not a joke. Where's Hoffa?
By the way, if anyone wants, go out, rent the movie Casino with Joe Pesci. All about the Teamsters. That's how they say they built Vegas.
That's an action item for Vinny. Put that one up there.
Yeah, go watch
Casino.
Casino.
And I've been told to say that the donate to National Right to Work was my suggestion. I put that on this list because they do such good work, and they are literally the only place an employee can go to have their rights vindicated in court. There's nobody else who actually, you're either in the employment law area, you're either a management side lawyer like me, you're a union lawyer. And if you're a union lawyer, you're not fighting for employees against the unions that are paying your dues. So National Right to Work is the only organization that's funding this type of litigation that's so necessary.
And that's the fifth
Muslim
web.
legal program there too.
Good, excellent.
Yeah, that's the fifth one down is the National Right to Work. I guess one thing I forgot is Peter List over at Red State does the labor union report. Essential reading, just great, quick blog posts that tell you everything you need to know. Peter List, it's Red State labor union report. So also essential reading. And with that, any guys want to add anything? I'm pretty satisfied. Thank you for holding the applause, guys, till the end. I really appreciate that.
Read Bill's columns in the Washington Beacon. He does great work. He does great work. Yeah.
I'll pay you later. Thank you very much, guys. Appreciate it.